On October 26th of 2018, this defendant shot and killed 2 of his friends.
That, ladies and gentlemen, by itself is reasonable doubt.
Hello, everybody. Attorney Martin Radner here from Radner Law Group, bringing you trial analysis on some of the very important trials that are sweeping across our nation. Today, we're going to be discussing the YNW Melly trial. We're going to be looking at the opening statements, seeing what was done very well, what could have been done perhaps a little bit better. But before we do, please like and subscribe to this channel. I have a partner who's very skeptical about what I'm doing, and I think it's important to bring content like this, trial analysis from experienced trial attorneys to you, especially about these very important trials that are sweeping across our nation. So let's go right into it. So first of all, as a disclaimer, I don't specifically like Melly. I don't have anything against Melly. I don't have a dog in the fight. I'm just going to be discussing the attorneys' presentations. Now, what they both did very well. And as you know, I do not like when you read your opening statement to the jury. It just doesn't come across authentic. It comes very scripted. And you want to be able to connect with the jury. That's kind of what opening statements, and anytime you're speaking to the jury, you want to build a rapport with the jury. So reading opening statements, they both did not do, and that's fantastic. Also, they got away from that podium. They didn't just stand in front of that podium. When you stand by the podium, you're creating a barrier between yourself and the jury. You want to get around, get away from that podium, and just talk to them like you would in a regular, normal social setting. So they both got away from the podium. There's actually one time a trial that I was involved in where the judge required me to stand by the podium. He did not allow me to get away from the podium. He required all the attorneys, if you're going to talk to the jury, you got to stand in front of that podium. I didn't like it, but when you're in that judge's courtroom, you got to do whatever the judge says. So that's what we did. But if you're able to get away from that podium, you got to do it. And that's what they both did here. So in terms of that presentation, they didn't read the opening statements. They got away from that podium. They talked to the jury right to them and spoke kind of like from their heart. That was fantastic. So let's talk about the prosecutor's case first, or their opening statement. So first of all, she starts off very strong. Take a look.
On October 26th of 2018, this defendant shot and killed 2 of his friends.
Now, why does she have to start off that way? Why does she have to get up right away and say, this guy's a murderer? And the reason why she's doing that is because you see the jury sees this person sitting there. He sees the defendant sitting there. He's sitting there. He's dressed in a suit. He looks innocent. And she's got to paint him as a murderer. So right away, she's got to give them the impression that this person that you're seeing sitting there is not just a regular innocent person. He's a guy that's a cold-blooded murderer. And understand that from the get-go, that's how I'm going to be discussing him. That's how I'm going to be referring to him. And that's what I want to ingrain into your minds, that this person is, even though he sits there looking innocent, but he is a full-blown, cold-blooded murderer. So that's why it's important for her to start off that way. Okay, so that was fantastic. Another thing that she does is that, which I thought was great, anytime that she discusses drive-by, which is what their alibi is, right? We have 2 versions of the case. Either Melly in the car shot his 2 friends, or this was a drive-by shooting. Those are the 2 options of the case. So anytime she talks about the alibi, that there was that this was a drive-by, she does this, drive-by. She always does it. Anytime she mentions drive-by, she does drive-by.
Henry runs in, starts telling a story about a drive-by, quote-unquote drive-by. That when the drive-by was staged at 4:02 a.m.
Now, why is she doing that? Why can't she just say, you're gonna hear from the defense attorney that this was a drive-by shooting, and that's not true because we have all this evidence that shows that there was not a drive-by. Why don't you just do that? And the reason is, and I think it's so powerful, is that you want to put that image into the jury's mind. You don't want them to have to think every time they hear drive-by, oh wait, is the drive-by credible or is it not credible? And let's think about what the arguments were. Let's think about the evidence. You just want them to have that image of you saying drive-by. And every time throughout this trial, I can guarantee you that they hear that word drive-by, in the back of their minds, they're going to be having that image of the prosecutor saying drive-by. So I thought that was also a great tactic that she used. Also, another thing that she did, which is fantastic, is that she kind of coined a maxim. She coined like a rule. And she kind of told the jury, this is the rule. The rule is that evidence is the remnants a crime leaves behind. Take a look.
Because evidence is the remnants a crime leaves behind. And in this case, the lack of evidence is very important. There is a lack of any evidence whatsoever to support that a drive-by happened on Miramar Parkway. What would they look for? Shell casings, glass fragments, projectiles, tire marks. you're going to hear that there is none of that found whatsoever.
Now, the reason why that's so powerful is because now the jury kind of has a rule. They say, well, if this was a crime, if this was a drive-by, where's the evidence? Evidence is the remnants a crime leaves behind. If there's no remnants of any sort of evidence, that means that there was no crime committed. And a very strong part of our case is to say that their alibi makes no sense, because if this was a drive-by, there was no evidence discovered at all that this was a drive-by. And so every time the defense is going to be mentioning drive-by, so first of all, they're going to be hearing drive-by, and then they also have this rule of, well, there's this rule, there's this maxim that evidence is the remnants a crime leaves behind, and there's no evidence here. So that's going to also kind of put a thorn into the defense's side when they're bringing out these type of arguments. Now, some other very good things that she did, she also did anticipate some of the defense's arguments, and that we spoke about. Anytime during opening statement, you're not just supposed to be bringing out the strong points of your case, you also have to embrace the weaknesses of your case. You've got to, because if the jury's going to hear this information, they've got to hear it from you, and they've got to hear it with your spin on it. So you can't just talk about the strengths of your case, you've got to also bring out what the defense is going to say. The defense is going to say that my case is weak because of this and that and the other thing, and we understand that, and we don't agree, and this is why the evidence is going to show that it's not true. So you've got to anticipate and dispel the other side's arguments. So she does do that occasionally. So, for example, she says that people are going to say that he switched cars. Take a look.
What you are going to find is that after the surveillance footage is brought up, some of these other individuals say, oh no, we stopped. We stopped the car, and Mr. Dimmons on the side of the highway got out of the gray Jeep and got into the red Mitsubishi. But ladies and gentlemen, it's important to know and look at the details, because the details don't match up. One person says, oh, it's at this location. One person says it's over here on the side of the road. Look at what the physical evidence shows, and that's what I would suggest to you is the most reliable things.
So the reason that that's important is because she's embracing a weakness of the case. This is a defense. They're going to say that he switched cars, but this is the reason why that it's not credible, or why you've got to follow the data, follow the details, and you'll see that that's not credible. So that's good. She's anticipating their arguments, and then she's dispelling it. She also says that he acknowledged, he kind of called his girlfriend and said that he was involved in a drive-by. So he's kind of, now she's collaborating his story with Cortland Henry's story, that, yeah, they're both kind of seems like they made up the story, that they're going to say that they were in a drive-by when really this was not a drive-by. So some great things that we saw from her. Also, some very strong pieces of evidence that she has on her side to prove that Jamal Dimmons actually did this crime. So the strongest parts of her case, right, is that we got the cell phone data. You got the cell phone, this leash that when you have your cell phone around, we can track where you are.
But then what you're going to see is the cell phone evidence. The digital leash.
And that's very, very strong. People have been convicted because of that evidence. So that's very strong that she's got that leash with that his cell phone was always with him, and they're able to track him that way. Number two, the medical examiner. So she's going to say, she says, the medical examiner examined these in the autopsies, and they said that the fatal wounds came from within the car. If this was a drive-by shooting, then the fatal wounds should have come from outside of the car, from bullets coming from the outside into the car, and not from inside the car out of the car. So that is very, very strong evidence that she has the medical examiners saying that the wounds came from within the car.
The medical examiner's office is also conducting an investigation. You're going to hear testimony about the autopsies that were conducted on Anthony Williams and Christopher Thomas. And this is when the suspicion, the investigation takes a turn. Because at that point, the fatal wounds for Christopher Thomas and Anthony Williams are coming from inside the vehicle, from the rear driver's side passenger going out towards the passenger side. The other interesting thing the medical examiner's office is going to tell you is that when the drive-by was staged at 4:02 a.m., the victims were already dead.
Now also, finally, the way that she ends her opening statement is like this.
And Mr. Demmons responds very succinctly, I did that. Shh.
So that is very, very strong. It's almost like an admission. It's like a confession, if you want to call it that. Maybe you won't call it a confession, but it's very, very damning evidence for Melly. He basically said, I did it. So that is she has got very, very strong evidence on her side that he actually committed the crime. Now, certain things that I did not really love about her opening statement is that, number one, she did not talk to the jury about the burden of proof. When you're going first, when you're the plaintiff or when you're the prosecutor, that means you've got to prove your case. You're the plaintiff, you're the prosecutor, you got to prove your case. You've got to explain to the jury how much you have to prove your case by. This is not just the jury can be sitting there, well, you're going to bring out evidence, they're going to bring out evidence. Whose evidence is better? How do I weigh this evidence? And let's say your evidence is a little bit better than their evidence. How do I know what to do with this information? So you've got to, as the jury, as the prosecutor or the plaintiff attorney, you've got to tell them right away, this is the burden of proof. I have to prove my case by so much. And since this is a criminal case, she's got to prove her case beyond a reasonable doubt. So what she should do is that she should get up and explain that to the jury. She knows in the back of her mind that the defense attorney is going to get up there and start talking about a reasonable doubt, that they've got to prove their case beyond a reasonable doubt, and he's going to make a whole to-do about this. And he's going to talk about how amazing America is and how lucky you should feel that we're in this system, but the system is the system, and you only can convict him if you find that he committed the crime beyond a reasonable doubt. And she knows that he's going to do that. So why not steal his thunder? Why not you go first as a prosecutor and say all those things? Say, yeah, we're so lucky to live in America, and America is the greatest country in the world where they don't just convict people because they just feel like it. They actually have to drag a jury in here, get judged by your peers, and you have to prove beyond a reasonable doubt. And not only that, as the prosecutor, you should say, and I intend to do that. I'm going to prove that to you because I've got such compelling, such strong, such credible evidence that I'm going to prove my case beyond a reasonable doubt. And by doing that as a prosecutor, you're completely stealing the thunder from the defense attorney. When he gets up there and starts talking about reasonable doubt, the jury's going to say, yeah, I heard this already. I heard this from the prosecutor. So don't just waste my time and repeat this. So I think that was a big miss on the prosecutor's side to not talk about the burden of proof. Now, also, something that I thought also was just strange about her opening statement was that part of what you're doing as an opening statement is you're telling a story. You're telling the jury what happened in this case, and you're telling the jury why Jamel Demmons committed the crime. But she starts off the story with Cortland Henry coming into the ER saying that there's a drive-by, and then she kind of works backwards. Now, I understand that that's how the detectives got the case, right? The detectives got the case, they had to work backwards. But now that you know the whole timeline, you know the chronology of the events, so why not you start from the beginning? Say Jamel Demmons, he left his studio with some other friends. There's 8 people. They got into 2 cars. One car went home. The other car went to a deserted area. Jamel Demmons gets out of the car. He shoots the people, however you want to explain the story. He gets out. He shoots the people. Then Cortland Henry drives the car to the ER and makes up this whole story that it was a drive-by shooting. And the reason why we know it's not a drive-by shooting is because this, that, and the other thing. I think that would have been much more effective. When you start off with what they're going to argue, what their side of the story is, what their alibi is, and then I'm going to show you what that alibi makes no sense, I think that shows that you're on the defensive. And you're the prosecutor. You shouldn't be on the defensive. That's what the defense attorney is supposed to do. He's on the defensive. You're the prosecutor. You got to be on the offensive. So you right away say, we know Jamel Demmons committed this crime because of this. And we have a timeline. And we have cell phone data. And we have the medical examiner. And we have all this really, really strong evidence. And, you're going to hear that's a drive-by? That's nonsense because of X, Y, Z, and the other thing. But that way, the jury hears from you that you actually believe in your case. You have strong evidence. And that's what you believe happened. And you don't start off on the defensive. So I thought that it could have been much more effective as a prosecutor to not start on the defensive, start on the offensive. Now, another thing that she did not anticipate, or maybe she knew about this, but she decided not to talk about it, which is just peculiar to me, is that the defense attorney gets up there and one of the things he says is that this was a botched investigation. Take a look.
There are a number of leads that you will discover that were identified by the officers, but were either completely ignored or given short shrift.
So you've got all these leads, right? The prosecutor and the detectives, they had all these leads, And the defense attorney is getting up there and saying, well, they didn't really follow up on these leads. Now, the prosecutor knows about all these leads, so she's got to talk to the jury and say, we know that the evidence is going to show that there's been a lot of different leads that came up throughout this trial, and we investigated them properly. And the defense attorney may say that we didn't investigate them properly, but we feel what we did, and this is the reason, and the evidence is going to show you that we did investigate these leads properly. But she didn't talk about all the other leads or suspects that the defense attorney gets up there and goes through a whole list of them that the detectives didn't do. So why would she not anticipate that he's going to bring up that issue of all these leads that they didn't look into and try to spin it in a way that the jury can get the jury on your side? So she didn't do that. I think that was a very big miss. Explain to the jury why you didn't follow those leads. Explain to the jury why you didn't execute a search warrant for Cortland Henry. I think that those are big misses. Also, I don't know why she spoke about the gang affiliation. She says that that Jamal Demons, Melly, is obviously involved in the Bloods.
So what you will learn from the evidence, from the Instagram, from the private messages, was that Jamal Demons is a member of the G Shine Blood set.
So, but she kind of just leaves it like that. She kind of says, well, he was kind of getting involved with the Bloods, and you can tell it from the text messages, and therefore what? What are you trying to tell the jury now? What's the jury supposed to do with that information? Are they supposed to say, well, he's a gang member, so he must be terrible, he must be that he committed this crime? Is that what you're kind of trying to tell the jury? You didn't really explain what you're doing with that information. If you're going to give information to the jury, you got to explain to them what to do with that information, what that information tells them. And I feel like it was just a big question mark. Okay, so maybe he's affiliated with this gang. So what? Did the gang tell him to? Are you going to say that the evidence is going to show that the gang told him to shoot these people? Like what? So, but she doesn't really explain that. So it kind of left me as questioning why is she bringing it in at all. Okay, so that's has to do with the prosecution's opening statement. Let's talk about the defense's opening statement. So the defense starts off with prosecutors have great power and endless resources. Take a look.
Prosecutors are given great power, endless resources to perform their mission of pursuing justice. But that's not what occurred here.
And then he essentially goes into the idea that this lead detective on this case, he decides that this is the case that's going to make him a star. Take a look.
What happened here is that the lead detective, Detective Moretti, saw a video of Mr. Demons getting into a car 40 plus minutes before bodies were found in that car. And then he discovered that Mr. Demons was a rising star. And from that point on, he decided he's the only person that could have committed this crime. Because if you're involved in prosecuting a star, you become a star. This was his big break.
So essentially what he's doing, the defense attorney is saying that the prosecution, they have all this great power. They have endless amount of resources. And this detective, he's going to abuse his power. He's abusing his power because he wants to become a star. That's what he's telling the jury. That's kind of what his theory is. But he says it very strongly. And it's a conspiracy. It's obviously it's a strong conspiracy. And it's really hard to swallow. I mean, if you've got really great evidence that that's what happened here, then okay, it's a big risk to say that there's this tremendous conspiracy. People don't like conspiracies. People don't always associate so well with conspiracy theorists. So you've got to be careful when you're saying that this was just an abuse of power. This is a conspiracy. He wanted to become a star, and he just zeroed in with tunnel vision on Jamal Demons, and he didn't care about anything else. If you want to attack the investigation, which he's going to do, he attacks the investigation, says how bad the investigation is. If you want to attack that great. Why not just attack the evidence? And then when it comes to why did they do such a bad job in the investigation, give the jury some options. Say, I don't know for sure why they did such a bad job. If you just attack the evidence, you attack the investigation, then the jury's like, look, this investigation was obviously done wrong. It wasn't done properly. Now, I can give you some of my theories on this. It could be that the detective wanted to become a star. It could be that they're just completely incompetent. It could be other things. But if you lock yourself into one theory of the case and the jury doesn't buy it, it's very dangerous. Because even though you're saying, "Oh, this investigation was terrible," but what you're implying from that, what you're inferring from that, is that therefore he was doing it as an abuse of power. If the jury doesn't buy that, then you may have just lost your case. So I think that as a defense attorney, it could have been a little bit of a stronger case to just attack the evidence and then just kind of leave it open and say, well, maybe there's some theories, there's some ideas, and then kind of see how the case goes on, see how the evidence comes in, see how the detective does during cross-examination, and then see how the closing arguments work out. And then you can actually see whether you want to bring forth that theory to the jury, because it's a hard conspiracy theory to really bite into and to swallow for the jury. So I thought that was an interesting thing. Now, another thing that he mentions is he talks about motive. So listen to what he has to say about the idea of motive.
You recall Miss Bradley, some of you may recall, during jury selection, going to great lengths to let you know that she does not have to prove motive. And she's right about that. The law doesn't require her to prove motive. But you know what does require motive? A young man to wake up one day and decide that he's going to kill two of his best friends.
Now, when I heard this, I was just thinking, what's he trying to say with this? So he acknowledges that Ms. Bradley, the prosecutor, said that the law does not require her to prove motive. That's true. The law does not require her to prove motive. And he acknowledges that. But then he says, but it does require motive? Why a young man would shoot his two friends. What's he trying to do there? He just acknowledged that you don't need to prove motive. But then he says, it does require motive, why he would do it. Okay, where are you going with that? What are you trying to say with that? And then he kind of says, well, if we don't know why, then that in itself is reasonable doubt.
And that, ladies and gentlemen, by itself is reasonable doubt.
And I think that that's a mistake, because it's really incorrect. If you have a video of Jamal Demons shooting his two friends, and you don't know why he did it, he's guilty. Right? You can't find that he's not guilty, even if you don't know. So the fact that you don't know why he would do it doesn't tell you automatically that there's reasonable doubt. So I think that what he really meant to say, and perhaps could have said a little clearer, is that there's a big question in this case. Why would this guy shoot his two good friends? We're going to, I guess, have evidence that these three guys were all good friends. So for somebody to shoot his friends, it's a big question. Why would he do that? And what that does, that in itself doesn't create reasonable doubt. But you know what it does do? What it does do, it should bother you that therefore any evidence that comes in, you've got to look very carefully at. And you've got to see whether this evidence really, really adds up. Because that question is so powerful that it should really make you look at all the other evidence and see whether there's reasonable doubt in the other evidence that the prosecution brings forward. So I think that that's really what he meant to say, and I think that that's what he should have said. He just should have said it a little clearer. Now, something else that the defense attorney said, he says that Ms. Bradley the prosecutor spoke about that Cortland Henry came in and he lied about a drive-by, and he just lied and lied and lied, and now she's trying to impute those lies onto Jamal Demons.
Now, Ms. Bradley started her opening statement by describing some of the lies that he told, as though to impute them to Mr. Demons. Those were not Mr. Demons' lies. Those were his lies.
And he says, well, those aren't Jamal Demons' lies. Those are Cortland Henry's lies. But the problem is that the prosecutor also said in the opening statement that Jamal Demons made a FaceTime call to his girlfriend and said that he was involved in a drive-by shooting.
Felicia Holmes and Mariah Hamilton see Jamal Demons outside, and he is saying he's just been involved in a drive-by, and he thinks Anthony Williams and Chris Thomas are dead.
So this is not just Cortland Henry's lies. I mean, if we're just going based on the opening statements, it's not just Cortland Henry's lies, it's also Jamal Demons' lies. He also lied about this drive-by. So the prosecutor is kind of showing this collaboration. That's what kind of she's doing. And if the defense is just, you can't just ignore the fact that he did make that phone call and he did say that he was involved in a drive-by. So you can't just say it's just Cortland Henry's lies and not his lies, because he also lied, if it's a lie. Now, something else that the defense attorney brings out is that the city of Marmor did such a terrible investigation. It was so bad that the Broward Sheriff's Office came in and said it was so bad. Take a look.
But beyond that, 3 years after arresting this young man and sticking him in a cell, the state looks at its case and says, oh man, this looks a little incompetent. Miramar Police seems to have botched this investigation, and they call the Broward Sheriff's Office and ask them to come and look at the investigation upon which this entire prosecution rests. And he looks at it, and he says he instantly knew he had to start from scratch. I think his words were, it was the worst thing I had seen in my life.
So you've got to be careful with this argument. And the reason is that you're asking the jury to believe the Broward Sheriff's Office or not. Are the Broward Sheriff's Office good? Are they good at their job? Did they do a good investigation or not? If you're asking the jury to trust them, that the city of Marmor did such a terrible investigation, but guess what? The Broward Sheriff's Office also came out with the same conclusion, that Melly is the one who committed this crime. So you got to be careful. Wait, I'm asking you, as a defense attorney, I'm asking you to trust the Broward Sheriff's Office that the city of Marmor did such a terrible job in the investigation, but not to trust them when they themselves came out with the same conclusion? How do you split that? You know, how do you play in both sandboxes? Either we trust the Broward Sheriff's Office Department, or we don't. Now here's something interesting. He says, well, I also have problems with the Broward Sheriff's Office's investigation. Take a look.
And we have problems with the Broward Sheriff's Office redo as well, but you're going to hear about that during the course of this trial.
Now, when he's saying that, right, he's saying, well, he just spent a good amount of time saying why the city of Marmor's investigation was a sham. Right? It was just a botched investigation. He spent a lot of time on that. And now he says, well, I have problems with the Broward Sheriff's Office's investigation also, but I'm going to let you hear about that when the evidence comes in. Why? Why are you going to leave us all in suspense? You just had all these great reasons that the city of Marmor's investigation was terrible. You can't give us at least one or two reasons why the Broward Sheriff's Office investigation was no good? But why would you do that? So it kind of left me hanging. I think leaves the jury hanging. Like, wait, what's going on here? I'm confused whether I should trust the Broward Sheriff's Office Department or not. And now you're saying that they also did a bad investigation, but you're not going to tell me. Why wouldn't you do that? So that's an interesting problem. Now, another thing that he does, which I thought was fantastic. This is something that the defense attorney did, which was just great. He tells the jury about their job. And that's so important. You want to tell the jury what you're here for. This is what you're here for. You're here, you have a job. Everybody wants to know, what am I here for? I'm going to be spending the next 6 weeks of my life doing this. Tell me what my job is. So he says, I'm going to tell you what your job is. Take a look.
Jurors often get confused as to their mission. You can't do a job unless you know what that job is. You're not here to judge Mr. Demons. You're here to judge the sufficiency of the state's case.
So that's so powerful. You're not here to judge Melly. You're here to judge the state's case. That's just fantastic, because as a defense attorney, you don't want them focusing on your client. You want them thinking about the state. You want them judging the prosecutor. You want them judging the detective. That's what you want the jury doing. And by him saying your job is not to judge Melly, Jamal Demons, your job is to judge the state's case to see whether there's any reasonable doubt, that just takes the whole focus and the whole pressure off of your client, the defendant, and puts it on the prosecution, which is fantastic. That's exactly what you want the jury to do. And then also he says that you're not here, like the example that he gives about milk and fat-free milk, you're not here looking for milk, you're here looking for fat. Meaning you're here looking for reasonable doubt. That's what your job is. Your job is to see, is there any reasonable doubt in any of the evidence that they brought? And if there is, then you've got to, you can't convict the defendant.
You're not here looking for proof. You're here looking for doubt.
So that was also just fantastic, just telling them what their job is here and putting the pressure and focus on the prosecution. That's fantastic. Now, he has to respond to some of the arguments that the prosecution makes. And some of the arguments that he does not respond to, which is the medical examiner. He doesn't talk a word about the medical examiner. The medical examiner is going to say that the wounds came from the car. What is your defense to that? Now, it seems that he's going to be arguing that he wasn't in the car at the time. And the only way to do that is by saying, well, the problem is you got the cell phone data that's saying that he was in the car. So what are you going to say with that? So he kind of brings forth some arguments. He said that, well, they kind of use these phones. First of all, the phone doesn't come back to him, which I think means that he maybe wasn't the owner of the plan, and he was just kind of somebody took out a plan with 4 phones and gave him a phone. So that's number one, which is not so compelling. It can still be his phone. And then number 2, he says, well, everybody in the house kind of used the phones interchangeably.
What they fail to tell you is that phone comes back to the name of somebody other than Jamal Demons. What they forgot to tell you is that their own witness will tell you that, yes, that phone and Mr. Williams' phone and a number of other phones were all in the same account, and all of the people in the house used to use them interchangeably.
And that's just hard to swallow. It's very hard to swallow that people would operate that way. Who operates that way? The jury's supposed to use their common sense of the things that they're exposed to every single day. Do people just, interchangeably change phones with each other? I mean, what are you supposed to do? Give out 4 different numbers? If you can't reach me on this number, try this one, this one. Everybody has a phone. Everybody has a number. And also, remember that the prosecutor said that he actually gave out this number after he committed the crime. He gave out this number a few times as his number. And he didn't give out 4 numbers. He didn't say, well, it's one of these 4 numbers. Try to reach me on any of these numbers. He gave out this specific number, which the cell phone data is going to track, which was in the car.
And so, ladies and gentlemen, specifically, the Instagram, the defendant, during the course of the months of October of 2018 through December of 2018, gives out his phone number 15 times. Says, this is me, and all during the same time frame of October 26th of 2018, he's giving out that phone number.
So there weren't such great arguments about how to disprove the cell phone data and the leash that was created to say that he was in the car at the time. And he also didn't talk about his admission that Melly said, I did that. He said, I did that. So, how is he going to overcome that? So there were some very strong points about the defense's case. There were some weaknesses also. And we're going to see as the evidence comes out, as the trial progresses, we'll see how this all plays in, and we'll see what we're left with during closing arguments. So that is my take on the opening statements. Thank you very much for watching. Please like and subscribe, and looking forward to continuing to bring you this analysis.